Yeah, everybody please settle down. And those outside the hall may please come inside. We are running behind schedule, so we want to cover up in this session. Therefore, I would be requesting our next set of speakers and the comments to be, curtailed a little bit just to make up for the lost time. So in this, after the inaugural session, this is technically our first session, and as we've been pointing out, this is not a one-way conversation from the stage, nor is it limited to you all just responding to the comments from the stage. It is a brainstorming of sort. The seating doesn't reflect that, but that is a limitation. Right. So in this session, data in criminal justice and why use it at all, it is, I think the word of our conference is provocation. It is a provocation, but of a slightly different kind, an obvious one, but that's how we are provoking you. And for this session, we have Justice S. Muralidhar, we have Professor Ashwini Deshpande, and we have Swagata Raha. I would like to start by inviting Professor Ashwini Deshpande. She is the head of the Department of Economics and the founding director, Center for Economic Data and Analysis at Ashoka University. And just to build on that idea that we in the justice space need to also look at other thematics, other sectors to enrich our own understanding, and that too all the time. And that is why we had requested Professor Muralidharan to give the inaugural address. So please, Professor Deshpande.
I don't have presentation. Thank you very much. Thanks, Anoop, for inviting me to this conference. I feel like a complete imposter because I have very little idea of the criminal justice system and the data intricacies. But I do work with data, and I've also established a center at Ashoka, which is the Center for Economic Data and Analysis. So based upon that, I'm going to just make a few remarks. And let me begin with an anecdote that sort of links to the points that were raised in the inaugural session. So when the COVID pandemic hit, obviously overnight there was a shutdown of all economic activity. And in the first round, all the shelter homes for domestic violence victims were also shut down because they were not seen as an essential service. Afterwards, after some protest, the shelters were opened. And what we started reading in the international media is that the first pandemic was the COVID-19 pandemic. But on the heels of the COVID-19 pandemic was the pandemic of domestic violence, because now women were sort of imprisoned with their abusers at home with no possibility of going out. And so one of the things that I immediately started to think about was what's happening to violence against women. And along with my colleague Kanika Mahajan at Ashoka, we started to see what data is coming out in real time, because this was happening, unfolding in the world, literally as the COVID-19 lockdowns were getting implemented everywhere. India had amongst the strictest lockdowns. So it turns out that the only data that we could get was from the National Commission for Women, which was reporting some cases. But most women, when there's a case of domestic violence, they don't approach the National Commission for Women. They go to the police, right? And so we started looking at trying to get some data from police stations about has there been an increase in complaints filed about domestic violence in the wake of the COVID-19 pandemic. And lo and behold, what do you think was the answer? No data, right? And so then we started using our contacts and trying to approach specific state governments to say, okay, can you just get data from your respective police stations, even if we get it for a few states, especially large states, we will be able to comment in a very tentative way whether there's been an increase, because we have older police station records, data from the National Bureau of Crime Records, right, NCRB. So we would do a very rough calculation, but we could see whether there's in fact been a pandemic of domestic violence in the wake of the COVID-19 pandemic. And we hit against a wall in every single state that we tried. And finally, the real answer came from the UP person who, many people in Ashoka, they have contacts with the UP government, et cetera, et cetera. And they said, if anybody can give you this data, it's going to be this person. And he said, listen, we are supposed to collate the data and give it to the national NCRB in a time-bound manner. By time-bound, you mean 1.5 years later. So when we have to give it to the NCRB, we'll give it. Who are you to ask us for data in real time? And I'll appreciate that question because honestly, who are we, right? But, and so it doesn't mean that government departments have to accountable to every scholar who wants to publish the next paper and say, okay, give me data because I need my, I need my scholarly output. And so I completely appreciate that question. However, it also revealed a certain blindness to the fact that this concern about women being locked up with their perpetrators was a very real one. And so while government departments are not answerable to individual scholars, and they should not be, I agree with that, but there comes a time when you have to understand what the issue on the ground is. And it's not to say that they should have given us the data, but that data should have been available for anybody to use, to see whether, in fact, domestic violence increased as a result of the COVID pandemic or not. Now, several years later, we'll have papers on that, etc. But that would be already too late. How do we know what happened to the lives of the women when they were facing that violence in real time? So the point being that just as the quality and the quantity of data are important, so is the frequency. And data are of different kinds. So there are some data that you do on like a census level, decadal. So you want to see the big picture change, the decadal change. So there's this data set called India Human Development Survey. The first 2 rounds are about 7 years apart. The third round that will be released will be about 15 years after the second round. So that gives us the big picture story of change in India along a variety of dimensions. That's useful. But things like labor force statistics, things like domestic violence, things like crime of other kinds as well, you need that data in real time because people's lives are getting impacted that very minute. Every time a woman is beaten, not just one person's life, but several lives in that family are getting impacted. So getting data in real time is also important for certain, so you can think of indicators as high frequency indicators. Google has this data on our apps, we all have Google Maps on our phones. And so Google is tracking like we walk from here to the T place, millions of data points got created, literally every time we take a step. That's extremely high frequency, high volume data. So we need data of that kind. We need big picture, decadal kind of data. But the challenge before the criminal justice system, as well as economists, for especially those who are dealing with policy, is how do you sort different kinds of data, which should be decadal, big picture, which also is needed, but we also need real-time, quick, high-frequency, high-velocity, high-volume data, right? And there are different kinds of indicators, or they may be the same indicator, but you still need data in real time. So now, for example, the labor force surveys in India have become annual, and for urban households, they do it, every quarter there's a revisit. That's excellent, because now you can get a much faster understanding of the way the labor market is functioning than earlier when you used to have 5-year surveys. Those 5-year surveys also have the utility, but the annual surveys make it easier to track changes in the labor force. Now, so that's one point. The second point is that most people are not trained in statistics, right? So you can throw a bunch of numbers at somebody and you'll say, okay, what was that? And so we see examples of literally XY graphs where the x-axis and the y-axis don't make any sense because you realize that this person forgot whatever graph theory they learned in school, and they haven't taken a statistics course subsequently. So just having the numbers, so one point is having the numbers and making them available to stakeholders. They could be researchers, they could be policy makers, they could be the personnel within the justice system or whatever, whoever, right? The other thing is, which is very important, is data literacy. Just looking at a bunch of numbers doesn't tell you anything. Okay? So to conclude the anecdote that I started with, finally we said, okay, wait a minute, nobody's giving us the data. So why don't we file RTI applications to every state headquarters, and we'll get the data. And so, optimistic as ever, Kanika and I said, okay, great, that's amazing, And so we, very enthusiastically filed RTI applications. Now many people are smiling, so you know what happens when you file RTI applications at that scale. So a lot of letters came saying, we don't have the data. So technically they've responded to our applications, so they fulfilled the needs of the law. And then started, I've taken pictures on my phone, literally, and I'd given my home address because, the university was closed. So I said, let me get the letters to my home address. And there started a barrage of letters in the mail arriving from literally some thana in some tiny place where in hand they've written in languages that I don't understand at all, detail of every single case, so and I felt bad because clearly some poor chap or woman has been asked to do that because the RTI application has been filed. And the postman got annoyed with me, saying, ma'am, aap karte kya ho? ये चिट्ठियाँ पे चिट्ठियाँ आती जा रही हैं. I said, भैया इस तरह की कोई चिट्ठियाँ है ना, मत डालना मेरे उसमें. Just don't even deliver it. So effectively, it was completely meaningless. I mean, maybe in an alternative universe, if I had put all that together, if I had, if I had the bandwidth, something might have emerged out of it. But effectively, it was meaningless. So data, when you can't make sense of it, when you can't connect the dots, is meaningless. And at CEDA, what we do is we take publicly available data sets that are survey data, that get survey data, which, like will have 100,000 observations, 200,000 observations. Most individuals, unless you're trained in an economics or a quantitative department, you can't make sense of all those numbers. So what we do is we create means, proportions, and by cuts that make sense to people. So rural-urban differences, let's say, male-female differences, differences between caste groups, differences between religious groups. And we make those proportions and means available on a range of socioeconomic variables at different levels of geography and different levels of at different points in time. So please, in fact, visit our CEDA data portal. And we have allowed interactive visualization so that you can actually create your chart that you're interested in. So data has to be made user-friendly for us to make any sense of it at all. So, looking at this, when I was thinking about these remarks, I actually went to the United States various websites, and I found that they actually have courses called Bachelor's and Master's in Data Analyst for the Criminal Justice System. I mean, students are learning to be data analysts for the criminal justice system. They are specialists in data, they know statistical methods, and they are focusing on data generated by the criminal justice system. That's the kind of investment we need to create data awareness and data literacy and accurate use of data in the criminal justice system. So, I was looking at Bureau of Justice Statistics, and I played around with some of the graphs. They have interactive graphs as well. And you can get, expenditure, employment, payroll statistics for police, judicial and legal personnel, corrections facility, total justice system, compare and rank, states' expenditures, employment, payrolls across criminal justice functions. You can generate calculated metrics of expenditure per capita, number of employees per 10,000 residents, average payrolls, US justice, view justice expenditures and employment, blah, 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 blah. I can go on and on and on. So that's how detailed that data availability is. And interestingly, universities are offering these courses of data analysts in the criminal justice system. So you're creating a stock of trained personnel who know statistics and who know the criminal justice system. So I think today, first short answer to the question of this that the panel has, should we be using data at all? Yes, of course. But in order to do that, we need to increase our own data literacy. We need to increase our ability to understand data and our ability to connect the dots, which is what data analysis does. So what data analysis does, you have one data point from here, you have another data point from there, and similarly many others, and then you connect the dots. And suddenly a picture starts to emerge, which is what, in fact, we do at CEDA. We also have the NCRB data. So we can correlate NCRB data at the district level with many other socioeconomic characteristics. So we can, if you want to look at the social determinants of crime, for example, you can do that using our data set. So we did, we have one, we also have a feature called data narratives. So in 2019, we had looked at the prison statistics data, and we had done a data narrative, and things that we think we know, but when it's pointed out, it's useful because it then makes us think about what's going on with it. So for example, our analysis showed that in 2021, 77.1% of all those in prisons were under trials. Now I'm sure everybody here knows about it, but I was shocked to see that number. And it's a number that should shock all of us, right? As the share of under trials grows, those awaiting trial are spending longer times in prison, so that prison statistics will give you that as well. Religious minorities, specifically Muslims and Sikhs, are overrepresented among the under trials and prisoners. Share of those from Dalit and Adivasi communities has been consistently high amongst India's prisoners. Now, again, the audience sitting here might say, oh, well, we knew that already, but these are data points that I would say, okay, we need to think and act upon these data points. And think about what's going on. So I was going to refer to three studies done by economists. One of them, Karthik already referred to, Manaswini Rao's, so I will not repeat that, but I'll talk about two others. And finally, one that I am actually also working on with another colleague. So there is another paper using the same prison statistics that examines the origins of judicial stringency in bail decisions. And it finds that if judges had an early exposure to a riot when they were literally kids, then they are less amenable to giving bail decisions later on in life when they become judges. Now, that paper has been, it's done a lot of checks. Again, somebody can find faults with it. But the fact is that judges are not operating in a vacuum. So the kind of exposure that they have, including as children, it's not unreasonable to believe that might have a bearing on their on their decisions. Now, whether you believe the results of this paper or not, it's not my paper. So, I just wanted to let you know that there are papers like this. But the point is that these are papers that compel us to think about the judicial process as reflecting an influence of factors outside the judiciary. The socioeconomic realities that produces crime, but that also produces judges, right? And so these are complex phenomena, and we need to think about that. The Rao paper, Karthik already mentioned, so I'm not going to mention that. But, so just as this one says, judges that were exposed to violence, riot violence as children are more strict in their bail decisions. There's another paper by about, I think, 8 co-authors that has looked at 5 million cases in the lower courts as a result of this e-courts data that's been made publicly available. And that, in fact, finds that even though women and minorities are underrepresented amongst the lower courts as judges, the decisions per se don't have any in-group bias. So that's a piece of good news, again, if you believe that result. Now, each of these is an academic paper. You may or may not believe it. You need to engage with the authors. You need to engage with the techniques that the authors have used to analyze the data. What this is pointing to is that availability of data can be used to connect what's happening in the criminal justice system with the social realities outside. A final example from my work in progress, which I'm doing with my colleague Anisha Sharma. So currently, as we speak, the question of should the perpetrators of rape be hanged, death penalty, is a very, very emotive issue at this minute as we are speaking. And there are lots of articles that have been written that yes, death penalty is the answer, because either it acts as a deterrent to future crime, or it is seen as a proportionate response to a gruesome crime, right? So there is, maybe not in this room, but in the wider public at large in India, there is a very big support to basically just hang the perpetrators, right? People, including government officials, have said that. What we've done is we've looked at National Crime Records Bureau data for 20 years, and we've looked at district-level correlates, different socioeconomic indicators. And what we find, and we've looked at hanging in a given year, and the impact of crime in subsequent years. And we look at 1 year later, 2 years later, 3 years later, et cetera, et cetera. And we don't find that it acts as a deterrent to future crime. It does not act as a deterrent to future crime. And we ourselves are not surprised by this result, because you find this result in every single country that you can think of. Yet, the support for the death penalty as a deterrent continues to be strong. Okay, you might say, okay, maybe not as a deterrent, but how about a proportionate response to the gruesome crime? There we have to think about what produces crime in the first place. Is it because individuals are just monsters and evil? Some people are, might be. However, crime is a product of socioeconomic realities. And so when we understand crime, we have to understand it as situated in a particular socioeconomic context. So what we argue in that paper is that the approach of the criminal justice system should not be law enforcement, but crime prevention. So it's not as though people are just bad people out there to just commit crimes, and we just need to crack down on them and just beat them into submission. That's not what's going on. If crimes are being committed, we need to figure out what is it that leading people to create those crimes, and focus on what strategies will work on crime prevention, both from inside the judicial system as well as outside, right? And not look at it as a law and order problem or a law enforcement problem. And final question, since we are talking about data, is the increasing use of artificial intelligence, particularly in countries like the US, used by judges to make decisions about bail and parole, right? And so there are these algorithms that are trained on the existing pool of prisoners. Now, because the incarceration rates for blacks are about 5 times as high as the incarceration rates for whites, the algorithms are trained on the existing prisoners' characteristics. So the prediction that a black prisoner who's sent out on parole or jail will reoffend is much higher than a white prisoner. So judges tend to deny black prisoners requests for parole or bail. But the mistake, in other words, if you see a black prisoner who was released, and did that person commit a crime or not? So the likelihood of the judges being wrong in terms of black prisoners is twice as high as the likelihood of, they overestimate the crimes that black prisoners let out on parole are likely to commit compared to white prisoners. That's because the algorithm has its own bias. And this is a whole field now in computer science. It's called algorithmic bias. So final point is that when we are looking at data, we cannot lose sight of empathy. We cannot lose sight of the socioeconomic realities that generate crime in the first place. And of course we need to be data literate. If we combine all of this, then we can still use big data, data analytics, perhaps even artificial intelligence, but make humane decisions. Because at the end of the day, law and the criminal justice system is meant for us to move towards a more humane society. Thank you very much.
Thank you, Professor Deshpande. I mean, there are many segues that you've given me to invite Swagata, who's the Director of Research and the Co-Director at Restorative Practices at Enfold. So I think given the debate, that is the segue I would use to invite Swagata. Thank you.
Thank you, Professor Deshpande. Indeed, I think your words have helped me open mine. I'm going to share with you, I'll start with a sobering thought. Mentor, which many of you are familiar with, Advocate Maruk Edenwala. Once we were having a very heated conversation on what research should Enfold be doing, and she told me, Swagata, no one reads your reports. It's gathering dust somewhere. Like, stop thinking you're so important. I was like, yes, that is indeed a very sobering thought that, we are investing so much of time and resources in looking at data sets, writing reports, and ultimately what does it result in on the ground. So my talk is going to be really about our journey of using data on the ground, what meaning have we made of it, and what has been our experience of taking an empathetic approach while looking at the child protection system. Yeah, sorry. I'll start with a reference to Alice in Wonderland. This is a passage that is capable of multiple interpretations. And yeah, sorry, can you hear me? Yeah. It's also a passage that my colleague Arlene and I actually used when we deposed before the standing committee that was examining the Juvenile Justice Bill, a bill that was introduced in the wake of the Delhi gang rape case, and a decision had to be made whether India was going to turn its back on its, a century of understanding of juvenile justice and start treating children as adults. So it's a dialogue between Cheshire Puss and Alice. She asks Cheshire Puss, would you tell me, please, which way I ought to go from here? That depends a good deal on where you want to get to, said the cat. I don't much care where, said Alice. Then it doesn't matter which way you go. I think it's a lot to do with how we interpret data. If we really are not invested in where and how we want to use data, then we could arrive at conclusions that can take us very far away from the very theme that we set out to understand better. In the context of child protection, I want to draw your attention to the manner in which data has been used in the space of policy making, and a very clear example of looking at data, and this is, I wouldn't say POCSO came into existence because there was data that was backing it. There were lots of other influences. There's Vidya in the room, who was also part of drafting efforts. But we see a clear reference to the statement, in the statement of objects and reasons of POCSO, to two things. One is the NCRB report on increasing sexual violence, and second, a study by the Ministry of Women and Child Development, which has also come under a lot of scrutiny. What was valuable from this study was, A, it gave us a sense of what was the extent of child sexual abuse, and second, that boys also experience child sexual abuse. And I think that was integral in ensuring that POCSO was a gender-neutral law vis-a-vis victims as well as the accused persons. Unfortunately, at that time, we did not have evidence on adolescent sexuality, and although the POCSO bill created an exception for adolescent sexuality, at the stage of the standing committee, there is this entire argument that the UNCRC considers child to be a person who's below 18, so we have to have 18 as the standard, even though, interestingly, it's the ministry who says our social reality tells us that those between 16 to 18 are sexually active, and if we are to bring in this law, it's going to really end up criminalizing a lot of young people. Having said that, the law exists as we know today, with the age of consent being 18 years. I'm taking you along my journey, so bear in mind there's also a chronology here. So this is 2012, December. I think all of us will be able to relate what incident I'm referring to. This is the Delhi gang rape case, where a 17-and-a-half-year-old was also involved. And suddenly we woke up realizing that the entire juvenile justice system was under question. Thanks. So what role does data play here? We look at the NCRB data, and I know those figures are barely visible to any of you, but essentially what it shows is that in a 10-year period, juvenile crime as a proportion to all crimes committed in India rose from 1% to 1.2% in 2013. So we're looking at juvenile crime being only 1.2% of all crimes being committed in the country. And within that, heinous crimes, that is commonly referred to as rape, murder, there are a lot many, were an even smaller proportion of that. We also have to bear in mind that POCSO has come into existence, and now the age of consent has moved from 16 to 18. So we see a slight jump in cases of rape, but these are also cases where the possibility of it being consensual exists. All of this is put to the standing committee, and the standing committee is able to rationally engage with the NCRB data, and also understands that NCRB data is based on FIRs, not on actual convictions. And looking at the percentage, they say it is absolutely low. one exceptional incident cannot be the basis to change the law. And here you see that the data interpretation is guided by the philosophy of juvenile justice. So the standing committee reminds us, one must not forget that juvenile justice law is based on a strong foundation of reformation and rehabilitation rather than on retribution. Now the same data is looked upon by the government, and we see a completely different conclusion being arrived at. I think this was said earlier by Professor Karthik, when vote bank politics starts playing into how we look at data, present data, collect data. And here you see that the public sentiment was clear, a change had to come. So how do you look at that same data, look at absolute numbers and say it is increasing? There is an increase, and the law is then a sign of being ill-equipped to actually deal with this increasing crime. And that's when the JJ Act comes into existence, which now allows for children to be tried and punished as adults. Now, when faced with this, when you're looking at public sentiment being so high, images of the parents of the victim being splashed in every newspaper, in every news channel, how do you again look at humanizing this entire situation? And there are many in this room who are part of that campaign, intense campaign of trying to identify how do you humanize that child. And here I slightly disagree with Professor Deshpande. We believe there are no monsters. In the context of child protection, we will say, I don't think there's any child who is incapable of reform. And then began the use of narratives. How do you find narratives of children in conflict with the law who can tell us what their journey has been, what led them to that life of crime, and what is their expectation of the law? So here are some statements that we gathered from a focus group discussion, as well as a testimony of a child, third one, which actually was sent to every single parliamentarian and also was then picked up by a particular member of parliament who wrote an op-ed about it, saying how this is a bill for juvenile injustice. And you also find this mentioned in the Lok Sabha, Rajya Sabha debate. So I think the point that I'm trying to make is how you use data, and I'm looking at silver linings here, because of course the law does not reflect anything that the data said. The law does not reflect what the philosophical, legal, foundational arguments that were made. But yet the law, in the history of the law, it's still recorded that there were some who did say that evidence does not support this move. And I think that is a silver lining that we can hold on to. So here, this particular child's case, I just want to take a moment to share with you, exemplifies what's also wrong with the justice system, because she was 12 years old when she was trafficked. She was working in a brothel. She came down with a disease, and the brothel keeper said, the only reason I can keep you is if you go and find 2 more girls who can do your work. And that's when she gets caught. So she gets caught when she's trafficking 2 other girls at age 16, enters the system as a very angry 16-year-old who says, what wrong did I do? No one came to save me the day I got trafficked. And why is everyone saying I'm the one who's wrong here? So it was her story that was extremely powerful, and she would, this would constitute a heinous crime. In the given law, she could be tried as an adult. So it was her story that was carried through in Parliament to say the law cannot change. We move on then, and here comes an opportunity to look at how POCSO, the Protection of Children from Sexual Offences Act, is being implemented. I had worked at Lawyers Collective, and I had seen how the Staying Alive reports that were created to actually document the way in which orders were being passed under the DV Act. And I thought it was an important learning from there that we can apply it to child protection and see how is the POCSO Act being applied in different states. So this was conceptualized in 2013, 2014, where we focused on 5 states in India, looked at e-courts data. So here is looking at what is the data source. The data source is judgments painstakingly downloaded one at a time manually from e-courts from 5 states, but not just the e-courts data, but also supplemented with interviews with various stakeholders working within the system to make meaning of that data. Because the numbers can tell you something, but talking to people will tell you what it really means. And Shraddha is here. She was part of 2 of those studies in Maharashtra and Andhra Pradesh. It also expanded our understanding of what is a justice gap. I think till then we had seen studies that focused singularly on conviction rates and pendency. But this made us go beyond that and to look at what are the procedural gaps in the implementation of the law. What is the manner in which child-friendly procedures are being adopted. Do we see the same biases that we see against adult women play out when it is an adolescent victim, or it is a child victim where the judge expects that the child should have cried, should have immediately told somebody, there should have been an injury, and also discover along the way new issues that we had no idea about. So we understand that age determination becomes a very critical fact in any case involving a child in the criminal justice context, and how contested that can be. We spoke about compensation in the morning, and this was again a source of data on compensation telling us no court was awarding interim compensation. Final compensations are barely awarded. So again became an important data point to then work with judges to tell them that they have the power to order compensation and not simply recommend the DLSA to do it. A very, very significant finding from this particular study was that there is an important link between the relationship that the child has with the accused and the manner in which the child is deposing in court. The likelihood of the child not saying anything incriminating against the accused is very high when the accused is a father, brother, a relative, or somebody very closely known to the child. The other aspect that also came through is the existence of romantic cases, and I'll be happy to answer what I mean by romantic cases, a term that is not defined in law, but defined by us. And here is when an opportunity came to actually use this evidence. We spoke about the death penalty. This is not new to us. I think 2018 is again when we saw clamors for the death penalty. And I will say this, I don't think child rights organizations looked at data to say we are against death penalty. Many child rights groups and organizations fundamentally did not think the death penalty was the answer. But the data helped us, I would say, take a very strong position that this move would be anti-child. We were able to articulate very clearly how this would be anti-child because, as I just said, the link that we saw between the relationship of children with the accused and how it played out, suggesting that this would have more of a silencing effect. So either you will not report the abuse, or if you do report the abuse, you will not go through with it and depose against your own father or your sibling or your relative. So that's something that we did. Again, silver lining. Of course, the law introduced the death penalty, but the silver lining here is, I think it brought people together. And I think we spoke in, I would say, in literally one voice, saying that this is not what children or child protection needs. What else can data do? And since we've done a lot of work on eCode's data, it can also tell us about a particular offense more than existing data sources can. So if I pick up child marriage, we know that child marriage, NCRB will tell you Prohibition of Child Marriage Act, very few cases filed. And that's because it follows the principal offense rule. So if there's POXO and child marriage, this will come as a POXO case. You will not know that there was also a child marriage. NFHS also is not telling you, yes, it is a child marriage. It is not telling you, is it an arranged marriage? Is it a forced marriage? Is it a self-initiated marriage? And internationally, the conversation has moved and has become far more nuanced in the context of child marriage, because the intervention for child marriage will depend on what is the nature of child marriage that we are talking about. So the judgments gave us that opportunity to look and be able to unpack and see, at least in our pool, that almost 50% of cases are self-initiated marriages. These girls are running away from violence within their homes or a forced marriage, and that's what's leading them to get into a self-initiated marriage. So how can that inform the manner in which we are looking at the criminal law to resolve something that is, deeply influenced by socioeconomic factors? Again, I think voices of children are so important, and I think just to take away from what Karthik said, like how state incapacity has been central to deciding our research priorities, because we work with children on the ground. We work at, with judges, police, as trainers. We're also working at the policy level. So we are able to see the poor translation of what is on paper on the ground every single day. And then to say that, we are protecting these children because we will extricate them from this situation and put them into child protection system which will reform and rehabilitate them, the children will tell you themselves what that system does to them. Another learning has been, when you design research, if you really want that an uptake of your research, you have to bring all the parties involved who have the capacity to take that research forward. So I'm giving you an example. I can't share this research is never going to see the light of day. because there's something so unsettling about young adolescents telling you, within state custody, telling you how the systems have failed them. But this was a research that was designed in cooperation with the state, and it was the state who initiated it because they were very concerned about the number of girls living in children's homes who were involved in quote-unquote romantic cases and languishing them there, waiting to turn 18 so that they can join their partners. And these are questions that the girls asked us. I'm reading it out in Hindi. I will translate for those who don't know Hindi. The first one says, मेरा ये कहना है कि अभिभावक 14 साल में ही लड़कियों की शादी करा देते हैं. उन पर तो कोई केस नहीं होता. फिर सहमति से शादी पर केस क्यों? She's saying that, when guardians marry off their daughter at age 14, no case is registered against the guardians. But why is the case registered when I, with my consent, went with my partner? It also gave us, ways of understanding criminal justice data. Look at the way in which data is presented. So you will get X number of kidnapping per year in the NCRB report. X number of girls kidnapped for the purpose of marriage. And the girl saying this to us, I was kidnapped, but why did the girl run away? Have you asked that? So she's saying, she's using the legal terminology of kidnap because that's the case that has been registered against her boyfriend. But she's saying that, have you asked why I ran away? So it again, challenges your understanding of numbers you see in an NCRB report, which is telling you this is X number of children who were kidnapped, there are X number of children missing, but we have to, read beneath those lines and understand that these are not children who have kidnapped. These are children, many of whom have willingly walked out of that house. So this led us to, of course, our work on understanding the scale of the problem. Because yes, our ground level experiences was giving us an insight into the number of children entering the child protection system because of being involved in cases like this. We had also done POCSO studies which told us the extent of it. And now, how do you decide what proportion, how do you understand what is the scale of it? Because again, NCRB is not giving you that data. NCRB is just telling you rape, X number of POCSO cases. It is not giving you any breakup that can help you understand this. So this was a study that we undertook based on 1,715 judgments from 3 states, Assam, Maharashtra, and West Bengal. And following that, we wrote a policy brief. And here I want to emphasize that the policy brief was not based on this one single data point. It was based on engagement with international domestic standards, judicial decisions of the Supreme Court, High Courts, as well as interviews with stakeholders directly working on cases like this to understand the scale of the problem, the impact that they were seeing on young people, as well as the worries that they had if the law were to change, how can it adversely impact young people. So this policy brief comes out, and I want to talk a little bit about backlash too, because the research that we do can at times not be liked by those who don't agree with us. So of course, in terms of the reception to it, there was a lot of media coverage. There was, we got an opportunity to present it to judges of the Supreme Court, the High Courts, and several others working in the JJ system in India. And following that, we did see a lot of traction in media as well as High Courts raising this issue. The matter got referred to a law commission, and we also deposed before the law commission. The law commission, interestingly, recognizes the contest between autonomy and the need to protect adolescents, but does not go far enough to say that the age should be reconsidered. And just to clarify, we never said that the age should be lowered. We said it has to be decriminalized. There's a difference, but again, for another day. Then, of course, what happens is that one particular data point becomes the highlight of the entire study, which is that how could we say that 1 in 4 cases in our sample were romantic? And what was the basis of saying that? And I will stand here today and say I still stand by that figure, and I still say that that is a conservative figure because of the very narrow definition of romantic cases that we took. So everything else is discarded. You've discarded all the legal arguments. You've discarded the arguments related to international standards, domestic jurisprudence. The only thing that becomes a very problematic factor is saying that 1 in 4 cases in our sample, how could we say that they were romantic in nature? So moving on from that, how can we look at metadata of e-courts using algorithms? And I think that's also a conversation that's important to have. How we've looked at it is to contrast, and this is an important contrast. We didn't expect to find this. I mean, we did think that there will be some contrast, but this contrast is fairly stark. and tells you again what, the reliability of NCRB data. When we looked at CALPRA, that is the Child and Adolescent Labor Prohibition and Regulation Act, for 6 states, you see that NCRB gives you, for the same time period, it gives you a figure of 1,329. But when we looked at eCourt's metadata, we looked at 9,193 criminal trials. Even if you discount the principal offense rule, we find that there were 7,792 criminal trials that mention CALPRA. So I'm closing now. I just have 2 more points to make. What the key takeaways for us have been, what is meant by justice. I think through this entire exercise of working on child protection as well as criminal justice data, how do we look at justice in the way in which criminal justice system imagines it, and the conflation of justice with punishment and stringent punishment, how that can be challenged through data. And also in the context of child labor, what our study told us is that convictions are fantastic in Uttar Pradesh and Tamil Nadu. And what it doesn't tell you is that also the possibility of guilty pleas, of settlements in lok adalats, of no compensation to the child, and absolutely no rehabilitation. So our fascination with conviction needs to be really challenged there. And how is this going to impact when we say death penalty is the answer? How is it going to impact in the coming years participation of victims in trials and the overall outcomes? Also want to challenge the use of criminal law as a means to enhance gender equality, health and education, because that seems to be the go-to model at the moment. I think Valle has stood there. I have to stop. So the last 2 things I want to say is this. Looking at data, we've also realized that we have to pause to consider when disaggregation is not a good idea. Because there are times when we have to ask ourselves that question. It came up when we were doing the romantic cases study. We knew that girls were entering into relationships based on caste and religion lines. And how do you then ensure that that data is not used in other ways? So to opt for a more narrative-based reporting instead of actually collecting data of what caste did you belong to, what religion did you belong to. The correlation of health data with crime data in the context of children can be very dangerous because we have mandatory reporting. And what would that then lead to? Would it then mean that you start filing cases under POCSO? And finally, I think, of course, data challenges everybody knows. In the context of child protection, it is further compounded by protectionism in the form of confidentiality. So we cannot access any data relating to children in conflict with the law or children in need of care and protection because of confidentiality. And if you do get access, it comes with conditions that you cannot publish it. So on that note, I'll stop. Thank you.
Thank you, Swagata. Thank you for rushing you. Sorry for rushing you. Justice Muralidhar, after spearheading many transformative administrative judicial changes in Orissa, please.
Thank you. Thank you. We've had some fascinating presentations through the morning. And I've learned a lot, I must say. One thing I learned is how we project ourselves as the Indian legal system. And I was sharing with Karthik that we have ourselves to blame in what we project, and therefore make ourselves less understood to other disciplines. We've acknowledged within the Indian legal judicial system the importance of data. There's no difficulty as far as that statement is concerned. In the last few years, at least the last 10 years, we have this massive amount of data available online in the form of the National Judicial Data Grid. Professor Deshpande pointed out how one of the papers had studied it. I would like to see that paper, if you could share it with us, because one of the grievances that some of us as judges had was that even lawyers and judges were not looking at the data. We are yet to see, although the data has been there for almost 10 years now, we are yet to see any comprehensive study by law researchers of the data available in the National Judicial Data Grid. Statisticians will tell you about what they call granular data. Basically, you drill down. This National Judicial Data Grid does this amazingly. You look at India, then you focus on Maharashtra. You look at, let's say, Nagpur. You want to look into a court in Nagpur. And you want to see how many cases are pending in that court in Nagpur. You want to see a certain type of case in that Nagpur court, let's say 302 murder trials. And then you can find out individual cases and orders passed in those. So you can literally drill down to that level. So today it's possible to compare, and this is about the data literacy point you were making, it is possible to compare how long rape trials take in, let's say, state of Kerala. Let's say the time of the crime, the date of the crime was, let's say, 5th September of a particular year. On the same day, let's say, crime took place of a similar nature in West Bengal. You can actually use this NJDG to compare the trajectory of that same rape trial and find out which one progressed quicker, which one was slower, and why. Because those orders will also tell you who sought the adjournment, whether it was the prosecution that sought the adjournment or the defense lawyer who sought the adjournment. It's possible today with this amount of data to do that kind of research. Unfortunately, we have no people still who can actually study that data at the depth at which it requires. Because then you begin to realize that when we talk of the judicial system, it's not just about the output generated by judges. It's very complex. The whole system is very complex. Let me get you the example of bail applications. Somebody is in jail. As a lawyer, defense lawyer, I'm desperate to get him out or her out on bail. I go to the court. Typically, the judge will turn to the prosecution and say, what do you have to say? Because basically, the prosecution is supposed to explain to the court why this person cannot be released on bail. So standard excuses is, one, we are still looking for other accused. Our investigation is incomplete. This particular person has a history. So the judge then wants to know what is the history of this person. The prosecutor will typically say, sir, give me 3 weeks, give me 4 weeks. So in the Delhi High Court, we tried to cut down this to say, before you present the bail application in the court formally, give an advance copy to the prosecutor so that he doesn't come and take more time to do this. But the prosecutor will still say, sir, although the investigating officer is right behind me, we don't know the history of this man. So you want to have a report, a criminal tracking record report of this person. So 2 states experimented with this. Haryana was very successful. At the very first day, because we've been a judge in Punjab and Haryana, the very first day, they were able to give a report of the prisoner to say how many FIRs has the prisoner been involved in, what was the fate of those cases, and you could at one snapshot get the entire details without actually going further, for further hearings for this one particular statistic that you needed as a judge. Unfortunately, this has not been replicated throughout the country. So you have one sample in Haryana. When I was in Orissa, we said, let's pick up the Haryana sample. We had to then talk not to the police, we had to talk to the prison authority, most importantly. Unless the data held by the prison authority matches the data held by the police, matches the data held by the court, you can't complete the picture. So they came up with this idea in 2008 called the Crime and Criminal Tracking Record System, CCTNS. And then from that, which was to link all the police stations. Let's say the same person is involved in a crime in 3 or 4 states. You want to link up all those cases to say, okay, there is a history of crime for this person, or there are this many cases involving this person. Then they said, we'll take from that what is called the Interoperable Criminal Justice System, ICJS. So these things we've had in the government as responses to the need for analyzing data, but these things are not working. Simple thing. Ramesh Kumar is a very common name. In fact, in Allahabad High Court, at one time you had 4 judges with this name. And they were called Ramesh Kumar 1, Ramesh Kumar 2, Ramesh Kumar 3, Ramesh Kumar 4. I'm not joking. And none other than Justice Chandrachud, the CJI, present CJI, was the Chief Justice of Allahabad. And Allahabad has as many as 120 or 130 functioning judges. The sanction strength is 180. So for the Chief Justice of that High Court to get to know every judge is next to impossible. So Justice Chandrachud would be told, Justice Ramesh Kumar is coming to meet you. So then Justice Chandrachud said, I had, just below my table a drawer where I would have the photographs of all these judges. I need to know which Ramesh Kumar I'm talking to. So the inaccuracy of data. So Ramesh Kumar, if he spelled with R-E-M-E-S-H, will be a different Ramesh. R-A-M-E-S-H will be different Ramesh. R-A-M-A-S-H will be different. H is dropped, another. So the same person, simple data entry, you could be making a mistake. And it's so problematic. Anyone with an Aadhaar card will know how many errors we make in data entry in this country. So it's breaking down our systems for that one small first step that we take. When they were desperate to get people enrolled onto the Aadhaar database, they went to villages. They had the system of introducer. Because somebody had to introduce, let's say, a Ramesh Kumar to that data entry operator. And then Ramesh Kumar had to have a father's name. He had to have a date of birth. I have a target. I have to enroll millions. Why should I enroll millions? Some economist like Mr. Karthik Muralidhar will say, sir, World Bank ranking, you will go up in 2 points. Please do it. So we did it for a very different purpose. So we have a whole village in Kashmir where everybody's date of birth was 1st January. Everybody's date of birth in that whole village was 1st January. So if we are going to do this kind of data building, data gathering, then at the very first step, it's all going wrong, completely wrong. So we are not able to get reliable data. Just to clean up, in Orissa, the data held with the prisons, data held with the police, it was incomplete. I had 2.5 years. I had held meetings almost every month because I wanted this report to be produced before the court, saying in bail applications, so much time is taken up by the court, unnecessary adjournments, person is languishing in jail. Even today, this is why an essay, when you study the legal system, look at the track record of the Delhi riot cases. Just pick up those cases. See the number of times the prosecution has sought adjournment. And just because the prosecution says either the FSL report is not available or our investigation is still ongoing, or no, sir, we are doing a supplementary investigation. So this is just, I'm using legal language, but the delays caused by the prosecution, delays caused by the defense, so lawyers become a very, very important component. So I keep telling people, this issue is not about like manufacturing cars, right? More raw material, more workers on the assembly line, more cars. Judicial system doesn't work like that, and thank God it shouldn't work like that. Because this is about human lives. So merely because you're adding judges doesn't mean either the disposal of cases will become quicker, most importantly, the quality of judgments will be better. So when you look at statistics involving the criminal justice system, we really need to know the main cogs. Who are the persons controlling the progress of a criminal case? Let me take up 2 more examples. I have a criminal appeal before me. I'm sitting in the Allahabad High Court. If I get an appeal of 1995, I shouldn't be surprised, right? The appeal has been pending for the last 30 years. It's impossible for that prisoner to have remained in jail for 30 years, but it is quite possible there is a prisoner for 30 years in our Indian jails. Not surprising. Now, I need to know whether this prisoner is alive or not. Let's say the prisoner got bail after spending 15 years in jail. Some lawyer would have gone up to the High Court and said, sir, you're now only dealing with appeals of 20 years vintage. This is 25-year vintage. This is, this is, let's say, a 10-year vintage or 15-year vintage. The turn for this appeal will not come up now. 15 years is more than enough for a 302 prisoner to stay in jail. Please grant bail. And as judges, we have to. There's no question. It's ridiculous to keep the person. Suppose he's got a chance of acquittal in the appeal. For him to have already served 15 years means those years are not going to be compensated. So we do grant bail. By the time the appeal is taken up 10 years later, the man has been free. He was in prison for 15 years. He's been free for 10 years. And now we're looking for him. We're searching for him. Why would he remain in his village? After all, he has to seek his livelihood. He has to seek his future. So let's say he's moved out. And we have only so many policemen. If you tell the policeman, go hunt out this person in the village, that is not going to be his priority. So in many of those appeals, we get a report saying, person not found. So the dilemma for the judge, do I go ahead with this appeal? Do I not go ahead with this appeal? Some of us say, okay, we'll appoint an amicus curiae. and we'll anyway hear the appeal, because we are not supposed to, in law, dismiss criminal appeals for non-appearance of the counsel for the appellant. So this again is therefore an unsatisfactory. Let me say I dismiss the appeal. In normal course, this person should surrender and be put back in prison. We have no idea in how many such appeals where the conviction has been confirmed, the prisoners have actually been captured and put back. The flip side, there are a large number of cases where prisoners have served out their entire sentence and moved on, and their appeal is still pending in the court. And when some of us take up that appeal, we find there should not have been a conviction. Your heart literally bleeds. A man has spent 15, 16 years of his life in prison for a crime he did not commit. And today, as a judge, I find this was a case where his acquittal was plain, as you know, and I'm not able to do anything about it. I feel very bad, that's all. So when we frame new laws, brings me to the next point. There are already studies to show why we should undertake what is called a judicial impact assessment. You make a new law. I think Karthik mentioned 138 in that slide. I saw that one in the bracket you had put check bouncing, right? This one provision, 138 NI Act, has added to the pendency of about 15 lakh cases in this country. It's huge. It's taking up the time of most of our magistrates. It was not an offense. It was made an offense without realizing what impact it is going to have on the courts. Legislative impact assessment. I criminalize something. POCSO is a classic example. What in America, I think she didn't mention this phrase, they're called Romeo-Juliet laws. The precise thing she was mentioning. Because you attain an age where you're sexually curious and sexually active. So in some of the states in the US, they call this Romeo-Juliet laws. They do not criminalize it. But here we have gone and criminalized. So acquittal rates in POCSO are as high, I'm talking of Orissa, as high as 99% acquittals. And then we say the criminal justice system has failed, judges are bad. So I'm saying it's easy for us to label if you don't look at statistics or don't realize the impact of the laws on our society. Like you'll have low conviction rates in the Dowry Prohibition Act, low conviction rates in the Child Labor Prohibition Act, Bonded Labor Prohibition Act. Most importantly, again, the thing Swagata was making, very low convicting rates in the anti-terror laws. So there is a politics to this. And if we miss that out, we're missing out everything. So when we ask, is retribution the policy of punishment? We can cry till the cows come home that no, we have moved on to reformation, rehabilitation. But the fact of the matter is, for politicians, it's very convenient to whip up retribution as the main principle of punishment. So whatever the statistics tell us, we'll just ignore it, because right now to pass an immediate bill, send it to the president for his assent, for having one more offense for which death penalty will be the punishment, will get approval. We'll get a huge approval from the public. They don't understand judicial impact assessment. They don't understand before a court, you present evidence which is inadmissible, unreliable. The judge has to acquit. Witnesses who spoke to the police come and step into the witness box and say, we were tortured to give the statement. That's the end of the matter. So even victim statements recorded under 164 CRPC, the victim says, like she was pointing out, I was infatuated with this guy or he was infatuated with me and we ran away from home. And it was consensual. That statement will come in some 6 years, 7 years down the line. And the judge is he's helpless, has to acquit. So then it says failure of the judicial system. It's not just the judicial system, it's a failure of a whole system. So we are persisting with laws which we know will not change social behavior. Look at witch hunting, for instance. We have laws against witch hunting in so many states. The crime doesn't stop. So using law as a tool of social reform has been a huge challenge, and data should help us. But there is a politics to data gathering itself. If data presented to us is unfavorable or inconvenient, we'll ignore the data. Right? I think a classic example would be national versus international data. The World Hunger Report. Right? I don't know how you've dealt with it in your book. We'll decry the data. They'll say this is a conspiracy against India, right? If anything negative in an international report about India comes, immediately the government will not hesitate to say, disbelieve this report. We strongly condemn it, right? COVID data. If data shows India handled the COVID crisis brilliantly, front headlines, press conferences, if that data says, no, second phase of COVID you actually handled miserably, conspiracy. International conspiracy to defame India. So if this is going to be our attitude to data, that whatever is favorable for me, I will accept. What is not favorable for me, I will reject. Then we are not going to be making consistent policies based on data. Then state data versus private data. Let me take one example of displaced persons. I know that we are talking of criminal justice, but it will be relevant even here. We've had any number of statistics, or let's take not even displaced persons. We'll take of people killed in encounters. Encounter killings is not new to this country. Disappearances is not new to the country. Will you find any official report on encounters and disappearances? You will never. Whether it's a state government or the central government, nobody is going to say, this year, 2023, we wrongly killed so many people in encounters. You know the Hyderabad case? She talked about the December case. Hyderabad case, four of the suspects are supposed to have taken the police at 3 a.m. in the morning for a reconnaissance to reenact the scene and where it took place. All 4 were shot on the spot at point blank range. It took a committee appointed by the Supreme Court to find out this whole thing was a fake encounter. That report came out 3 years ago. Nothing's been done on it. We are not pulling up policemen. Probably some of those policemen have got promoted. So how we, and I'm looking at, let's say, data gathered in people's tribunals. There have been people's tribunals here in the Constitution Club is famous for people's tribunals. I have myself attended them. If you sat in the audience, you'll be moved to tears. There is a people, like she said, voices of children themselves. These are people who themselves suffered missing persons of families, persons killed in encounters, persons disappeared by the state. These are all forming part of reports brought out by PUCL, PUDR. Now, even if, let's say, Dr. Karthik was to sit down to analyze data, he will not touch the PUCL, PUDR reports because these are unreliable statistics according to you. No, you'll only look at official statistics. Suppose I was asked you to research on disappearances. What statistics will you get? You will not get any. So even in data on criminal justice system, we'll be making a serious mistake if we say we will go only by state data and will completely ignore data privately gathered. Because that data, and I know I've been representing in the Supreme Court victims of the Narmada Dam disaster, dam project. Sorry. I know how the actual number of people displaced never comes on official statistics. Always downplayed. And continues to be downplayed. So what we find researchers talk about, discuss, write books on, are all based on official statistics, which has so many problems with data gathering, data reliability, consistency of data, and no policy for collection of data. Another huge problem, right to information. So when we discuss data in any sphere, we are now talking criminal justice, but in any sphere, right to information, which is supposed to be an enabler, becomes a disabler. CHRI is here, Maya is here. The struggles, Anup is here, the struggles they have to access data. Much of the data of the criminal justice system is in court records, right? Very few people will get access to court records. The death penalty project could make a dent there only because it tied up with the National Legal Services Authority, which at that time was headed by judges who saw the value of opening up court records to researchers. Otherwise, it would have not happened. If today he were to undertake the same exercise, he'll come up with huge difficulties. I know you can correct me, But I know you'll come up with huge difficulties. In Orissa, I opened up the Orissa courts for visits by Vidhi and Daksh. I think there are some Vidhi people here, some Daksh people here, and IJR, because I believed our court should be open for researchers. But that's not a consistent policy of the Indian judiciary. But it's not the consistent policy of the state itself. So RTI is used actually to block off data. It's so simple to say, today you want to know how many judgments have been reserved in the Supreme Court, right, by various judges. You'll get an answer saying we do not collect that kind of data. So the act is interpreted to say only data which you collect, you can share, not data that you have. So if this is going to be the interpretation, and everybody works actively at frustrating the RTI Act. So when you look at data collection, data statistics, if this is not openly available for people to access, then we will not be able to use data effectively. The last is on privacy. I didn't see any of you mention privacy. It's a very, very important issue. You know, data generated today can be weaponized. It can be weaponized, it can be used to target. Earlier also it was being used to target. In Hitler's regime, they did this fantastic job of data gathering, data analysis. So they could immediately go to the house of the Jews without any difficulty. They could immediately pick up persons who are Jews without any difficulty. So the minute you use data as a weapon, we have a serious problem, and there's a clear danger of data gathered about the criminal justice system being used as a weapon. And we must be aware of this. In the digital age, data is being generated by the millions. I think Ashwini was mentioning this. There's a huge problem there. See, there is a camera here, right? When you step out, there'll be a camera at the entrance. By the way, just for lighten it up a bit, till now as a lawyer, I used to think that Article 21 was all about life and liberty. I didn't know it was about food. So if you step out now in this corridor and turn to the right, there is a restaurant by name Article 21. And I suppose it gets good food. In Orissa, between the stretch of just Cuttack and Bhubaneswar, they decided to have CCTV cameras for speeding. Speed limit was 80 kilometers an hour. With great fanfare, it was inaugurated. We are now going to check all these speeding vehicles. What they realized is, first day, 2 lakh challans were generated. And wherever those challans go, to the traffic court. Panic. So one device for gathering data had caused so much problem. Immediate impact. So unofficially, and this was shared to me by the person heading the traffic police, they decided only 100 kilometers and above, they will generate challans. They tweaked the program for that. That still resulted in 50,000 a day. So my judges, suddenly it was like a tsunami that hit them. We don't have the infrastructure for this. We've introduced a data gathering device. Again, so if you are not ready for it, let's not do it. Last, I want to end with this, and I'm placing it here. I don't know if the person who should hear this is here. With great fanfare, we have supposedly decolonized our criminal laws, right? We decolonized our criminal laws. It was a great finding of new freedom. None of those new laws was based on any data gathered by anyone, which is a tragedy, complete tragedy. Here we are discussing data on the criminal justice system. It was not informed by any data at all. It was not informed by the failure rates in serious offenses. We just introduced 2 more offenses which were part of special criminal laws: organized crime, terrorism. It's now part of the regular criminal law. What was the rate of conviction in those laws? No, nothing cared about it. We'll just introduce it because we are decolonizing the British law. I mean, we can be delusional and project ourselves as doing something fantastic, but the truth of the matter, which is what statistics tell a different story, right? But who's listening? If the state doesn't listen to its own statistics, then who else will listen? If the state, before drawing up a law, doesn't ask itself, in this country, how many instances of mass violence have occurred, right? Anybody will tell you, sir, 1993 bomb blast, before that the 47 partition, 2002 Gujarat, 1984 Sikh riots right here in the capital city, and yet crimes against humanity is not described as an offense. You don't have any machinery for that. So we are, I think, when we say that we are reforming, the statistics is telling us something, but we are just ignoring it. So unless we get out of the mode of data denial, we can't progress towards using data to improve our systems. And that data has to be very carefully used. Data about oneself is not available to oneself today. Like I wear a Fitbit, right? The recordings on that Fitbit, every now and then if I check, it's okay. But what my recording was last month or 2 months ago is on somebody's server, either in the US or in some other country which has offered space to your Amazon, Google, and whoever it is. So today we are in an age where we are not in control of data. The state is not in control of data. And here I'm talking mainly of digital data. So unless we have a robust data protection regime, which is so important for the criminal justice system, we'll be making a serious mistake if we do not correct all the flaws that I've been talking about in our criminal justice system. So I think I've covered most of it. Some of it should come in questions and answers. So just the questions that were placed before this panel, whether data brings some value to all aspects of the criminal justice, or we are better off imaging the significance role of data as being varied across different points of the criminal justice spectrum. Obviously, it can't bring value to all aspects. Like I told you, data can be weaponized, used to target. So we have to be very careful in how we gather data, how we don't build in biases into data gathering, and how we don't use data to target people. In thinking about criminal justice systems and processes, what precisely is the value of data within this sphere? Immensely value. As a judge sitting in court, I want to know about the prisoner who's brought before me. And it's immense value to me, provided it's truthful data. It's reliable data. Necessary part of this inquiry must involve reflections on whether different kinds of data end up being valuable in different ways, depending on the specific context. I think I've dealt with it. What are the dangers of not using data? Again, the 3 new decolonized criminal laws are the best example of dangers of not using data. Thank you. Thank you very much.
Thank you very much, Justice Muralidhar. The politics of data, and I think there is an assumption that we make that if we collect good data in a defensible manner and present it to policymakers, it will automatically lead to change, which is often not the case. Now the hall is open to questions and reflections, including those of the kind that Justice Muralidhar made, referring to the note for this session. And we have the mics ready. So, yeah, maybe 2 from here and then 2 from here. So starting with, please state your name and then ask the question or make a comment. But do keep it brief. We will break for lunch at 2. There's a red, push button.
Hello. Okay, I'm Nazimuddin Siddiq. I teach at Jamia Millia. I come from Assam. It was very interesting to hear Justice Muralidhar. So my question is that now we are operating judicial system which are meant for Muslims only in Assam. There is something called foreigner tribunals. With the advent of CAA, these foreigner tribunals are meant only for Muslims. Because all other religious groups, they get citizenship if they come from neighboring states. So what is your opinion on that? And because most of the people who are getting arrested there are, actually Indians, and they come out, if they have money to fight the case, they come out as Indians. And we also know from the ground and from our field work that these people are Indians. So how do you see this different functioning of judiciary based on religion? So that is my question to you. Thank you.
So maybe we collect 2. Yeah. Who was there? Yeah, go ahead.
My name is Vipul Mudgal. I work for Common Cause. We did a report. We bring out a report called Status of Policing in India report. and the last report was on surveillance and the issue of privacy. In that, we realized that the number of CCTV cameras and the data being collected through the CCTV cameras is humongous. Just to give you an example, something like in Vasant Kunj alone, which is like a very small part of Delhi, there are millions of terabytes of data being collected every day by CCTV cameras alone. Now, this data, there is no protocol for seeing the data. In fact, somebody was doing a research in a school, and they realized that the CCTV footage was being watched for entertainment by the owner of the school, in fact, the father of the school's owner, and along with some security guards. So they were, yeah. So the thing is that data, the trillions of terabytes of data being collected every day, and its effective use in any way, and there is no, there is no evidence anywhere in the world to show that this has resulted in reduction of crime, including crime against women. So that's one. The second part I have is about people's understanding of data. We asked questions about thousands of people, about maybe 8,000, 9,000 people. Are you comfortable with police using your data? The police getting hold of your mobile phone and taking everything. So until we came to the questions about your bank account, people said we are perfectly fine with state intercepting and taking everything away from us. So any comments on that? Thank you.
I think we can start with those two questions.
In this room, very few people will disagree with you that it's unconstitutional to have to have exclusive tribunal just for Muslims. Because you're labeling all Muslims by their very religion as the only persons who violated whatever that law is to face deportation. But that's a bias, inbuilt bias in the entire system. So what I would advise is you're not going to get official statistics on this. You can only get people's narratives. So the whole notion of subaltern came up, I think we should discuss that in this room. The whole notion of Ranajit Guha's pioneering work on subaltern studies came up because people are not going to volunteer to give statistics about themselves for fear of reprisal, right? So we need to gather statistics, at the same time make sure we present data in such a way that people are not able to be targeted for speaking. And then put it out. We need the media, we need all the resources at our command to make it public. So we say sometimes the data argues for itself, right? How reliably we collect the data, where we don't introduce elements of what we call confirmational bias. I think all the statisticians will tell you there's something called confirmational bias. I start off with a suspicion that this is how it should be. And I go ahead and establish that. So I'm saying that kind of rigor you must bring into your own data collection. And then this case argues for itself. But otherwise, as a policy, in going now by what the current establishment there is, this comes as no surprise to anyone here, I'm sure. But these things have been part of history. So this is not the first time this is happening. This won't be the last time it is happening, all right? And it is happening world over. So I'm saying we need to learn from all those examples and make sure that we build up a case that argues for itself. So that would be my advice. On CCTV, in fact, you go into a shop, right? You buy something. The first question the person at that counter says, sir, mobile number. How many of us unthinkingly give that mobile number? Just tell him, no, I'm not giving my mobile number. He'll go on to saying, are you paying by credit card or cash or whatever? Because they're not supposed to collect data. But we don't seem to value this data about ourselves. The whole culture of Facebook or Instagram or TikTok, we don't seem to value our own personal privacy. So this is the first problem that we encounter, and particularly the middle class and with the internet generation, that we're generating further points of data about ourselves, which cannot be anonymized and will be misused by anyone and everyone. This, I think, is because a general thing that is sold, that, the state is here for your good. Delhi Police's huge slogan is "with you," "Aapke saath," whatever that is. With you, for you, always. So this kind of a thing is constantly fed on the media, social media, everywhere. So a huge generation has grown up thinking whatever the state does is best for us. So this can keep people in levels of ignorance, which is why we need to talk more about it, expose it. I'm glad that there's a fact-check movement now. There's something called alt news. So you should go and seek it out. Of course, on your WhatsApp university, some of these things will not come as feeds, but one must learn to seek it out. But there is this problem that we have. It's a generational problem. We can't run away from it. And we have to keep talking more and more about it, about the dangers of this kind of data being readily parted with about oneself. And you're right, there's no proof to show that this has actually helped, and probably has helped distort cases. And I agree with you that unless we have a robust data protection law, which makes the state accountable, which makes multinational corporations accountable, how far with our data protection law we can make an Amazon accountable, or an Apple accountable, or a Microsoft accountable, Google accountable, I don't know. But we should have that law, and the state must be made accountable. State can't escape the rigors of a data protection law. I would add judiciary also must be accountable. We hold vast amounts of data, and now we have a petition on the right to be forgotten, because I get honorably, cleanly acquitted in a criminal case. Why should my name still figure in your judicial records for somebody else to pick up, to deny me employment, to deny me benefits, correct? Or to paint me as a person with a criminal record. So this is something that we watch with interest, how far we take this forward.
Just some order to this. Anoop, then the lady there, and then Professor Raghavan, after that Rohit. But first, Anoop.
Just seeking quick reflection from Professor Deshpande, that you said quite rightly that we might want to collect different types of data at different frequencies, and there are some data that you want to collect with high frequency which might influence decision making. But there seems to be a contradiction here, saying, especially in this context, the collection and the integrity of the data itself is suspect for various reasons, in terms of the person sitting in that prison, entering that data into that computer there itself, you are not sure of what's happening there. So how do we view this versus, should we rely on such data when the source itself is suspect for decision making that's something that just quickly wanted your thoughts on once. Yeah.
Hi, my name is Radhika, and I've been with PUDR for 12 years now. And as Justice Muralidhar rightly pointed out, my reports for all of these decades were not getting cited anywhere, so I decided to become an academic, and I'm here in that capacity. And just wanted to share some reflections on what Justice Muralidhar said about data serving a statist function, and that's something that I think we need to be also cognizant of. So when you say, for example, that the state doesn't collect data on the number of encounters or extrajudicial killings that that would have been perpetrated in fact, exactly, right? I think because if I pick up a newspaper and I pick up a news item that says, like at the time of the Sarkeguda encounters, that 17 quote-unquote Maoists have been killed in an encounter, and then 8 years later there is a Judicial Commission of Inquiry that says actually that these were not Maoists. So this is the state sort of extrajudicially determining certain categories of persons as terrorists or Maoists who deserve to be treated outside of the criminal justice system, right? It's just that all of this data that the state does collect, whether it is through the NAT grid or whether it is through the CCTNS, which are all mechanisms of surveillance and intelligence gathering over vulnerable populations, are not shared with me as a researcher, as a citizen, as an individual interested in democratic rights, under the national security exception, right, or the national security exemption. And very few of us end up addressing these exceptions, whether they're part of the RTI Act or in other places as well. It just reflections, right? Not a question. And I'll share the last note, which is, data serving a statist function, UAPA, low conviction rates. For the past, 30 years, we've been saying that the conviction rate under the UAPA is 2%. And so the law must be repealed. And the state has responded to that by enhancing conviction rates instead of repealing the law by way of, let's say, unofficial illegal plea bargaining mechanisms or, other devices. So just wanted to add on that caution about data gathering and data sharing serving a status function.
Thank you. No, Professor Raghavan. Then we'll come to this side. Yeah. But first, we'll take these three first. Yeah. Take the mic from Radhika, I guess. Take the one that's on.
Yeah. First of all, really, it was really fascinating listening to all of you. I have a question for Justice Muralidhar, which is that the Criminal Procedure Identification Act 2022 includes under trials. Isn't this unconstitutional? And the fact that one of the objectives of the criminal justice system is to rehabilitate people who come out of prisons, especially under trials. Today, for any job that you apply for, you are asked for a police verification report. And I'm talking from experience where we are facing this problem every day. So none of these people who come out on bail are able to find even jobs like housekeeping jobs. So don't you think this is an issue which needs to be challenged in court? Yeah.
I'm sure it has. If it is not, it's high time it does. Yeah. No, please come forth. I can now, I'm in a position to do it.
Professor Deshpande. Anoop's question.
And you can also have questions.
Thanks, Anoop. So, well, first, I just want to clarify that when I was talking about data, obviously I meant data that is carefully collected with I was thinking more of economic data where questions are certain standards. So when you look at, somebody's employment status, there are ways in which you can classify the person as employed or not, and things like that. So criminal justice was not on my mind at that point. And so when I was talking about quality data collection, that's what I meant. What I meant was that high frequency data is getting collected as, we saw from either CCTV or Google Mobility or Apple, various devices. So I'm not saying all of it should be used for criminal justice, and in fact, I completely agree that it depends on the politics of the time, and it can very easily be weaponized. And in the absence of good data privacy laws, that India doesn't have good data privacy laws, there's a real danger of our personal lives which are, enclosed in our phones, basically, just being made available for nefarious ends. The specific example I gave was for FIRs related to domestic abuse at a time when the NCRB deadline hasn't come. So if the procedure is that the police will give the data for the NCRB deadline collection, which is 2 years from now, 1 year from now, et cetera, that's fine, that's procedure, that's business as usual. But when you have a sense that during COVID, there is people call it the silent epidemic. And this was a pattern observed in several countries where police station FIR data was getting collected to show that women were the proportion of women filing complaints about abuse had risen during lockdown. But in India, we would never know whether that happened or not because that's what I was trying to tell you. So what my point was simply that it's not as though you collect data for the sake of collecting or you collect data without proper care or caution or none of those things. But if you have a sensitivity towards, and that's why I ended with empathy, which is at the end of the day, the whole point of this endeavor is empathy, right? And so when you think that there's a possibility that women are getting abused, just on this question of rape, etc., because that's so much in the news, the public perception is that all the violence against women happens outside on the home. So CCTVs, police on college campuses, police on the streets. That's not what we need. Majority of the bulk of violence against women happens either inside the home or by people known to them. Perpetrators are people known to them. So you can have as many CCTVs on the street, that's not going to solve that problem. So if you had that understanding, then you would say, okay, are women reporting? And this knee-jerk reaction of closing down shelter homes for victims of domestic abuse, just because it's not an essential service. Then they have to retract on that, right? So it just shows a complete lack of empathy, a complete lack of understanding of what the issues are that women are facing. That's what I was pointing to.
So over there, Rohit, then Ms. Borvankar.
Hello, hi. My name is Rohit, and I am currently a researcher at South Asian Institute, Harvard. I'm researching on history of punishment in India, and I'm documenting all the criminal justice data from 1823 to 2023, and we have crossed over 2 lakh data points. Some of the observations is that every year we listen that SC, ST, OBC have 65% representation in prison, and we don't see that if we see census, NFHS, the share in population is substantially similar as well, if 65 to 71% of OBC, SC, ST. What we don't see is कि caste और caste किस type के offences में caste का representation है, क्या वो NDPS है or is it forest rights case? So that's one observation. Second observation is more than 65% of the people are less than 10th pass. So is education something which have a correlation with the offences? And third thing is when there's a lack of political will. For example, if we see Jan Vishwas bill or we see GST council decriminalizing economic offences, how do we exactly shift to decriminalization for social offences? And just last observation is on decolonization is Natasha Narwal has put BNS to turn it in, and 83% plagiarism report came out. Thank you.
Ms. Borvankar, yeah.
मुझे लगता है स्टेट बीटिंग थोड़ा ज़्यादा हो गया है. वी हैव बीन क्रिटिसाइजिंग स्टेट टू मच, बट आई एम नॉट ऑन डिफेंसिव. So if I am heading a district and one private university asks for an information, I will hesitate to share the information because I'll be bombarded with too many private universities asking for information, like women being harassed or beaten up at home, domestic violence during COVID. So I feel NLUs would have better response than private universities. And CCTNS has been accessed. I have critically examined research by Nirvikar Jassal, totally based on CCTNS. He is a researcher where his topic was access to police stations by women and how that access is delayed, totally based on CCTNS. So my third point was encounters are being marked, and magisterial inquiries is essential. So I won't agree that encounters are being not identified. Then e-pendency and the figures shown by NCRB can be different because e-court pendency is maybe for last so many years, and NCRB data maybe only for that particular year.
I think.
Then criminal justice system, if I give subsidy to a person, you immediately see the result. If you want to have changes in criminal justice system, it will take so long to show any result. Therefore, I feel there is very little political will to change the system. There are so many actors in that. And my last point is, yes, government data read with the privately collected, academically rigorous collection of data is the way out. Thank you.
So I think those were a set of reflections from Ms. Borwankar, who is a retired IPS officer, has served in Maharashtra and at the BPR&D. Yeah, so there is a question right there in the first row, and then after that Radhika, and then over here.
Hi, my name is Akshay. I'm in my 5th year of BLB Honours course at NN Delhi. I'm a petitioner of a PIL which concerns with this, in Punjab Haryana High Court, which concerns with this type of consensual rapes or this love and Juliet laws. I had this question on the basis of the study that Swagata ma'am have done, and I wanted to ask, so even if there's no decriminalization, are there some factors which ma'am have collected or studies have shown which help at least a judge to grant a bail to decide whether this was a case of informed consent or not? Because if I'm not wrong, we have a decision of S. Varatharajan of Supreme Court which talks about kidnapping, where bail was granted and some factors were given. Those factors again refer to whether the person was whether the girl in that case was educated. There is also a bias, that urban-rural bias, so if the girl is from urban, then she has more consent and more likely to have consent. So are there some factors which can at least help a judge to give bail, because that's what he has, unless the policymakers comes to that factors to decriminalize? Thank you.
And this one more from Radhika over there. Yeah. Then we'll go to the panel. Maybe we'll have Karthik also. Yeah. Then we go to the panel.
Good afternoon. My name is Radhika. I also work on the status of policing in India report along with Vipul at Common Cause. You gave the example of, sir, thank you for the very interesting, sessions. You gave the example of the bail orders at court and how CCTNS and then ICJS sort of helped in providing data to be able to make those bail decisions, etc. But also at the same time, we're working on one of our new reports, which one of the findings among many shows that the lack of willingness of the police personnel as reported by them to give station bail in bailable offenses also, which has nothing to do with the availability of data about the background of the accused. So, I mean, these are sort of coexisting realities, and it's not so much a question, just a reflection on, on the one hand, data is necessary to be able to effectively follow the, rule of law and due process, but also there is some sort of an inexplicable sort of lack of willingness in the system to be able to, just abide by the law.
Right. Karthik, last one, if you want to quickly go.
This one. Yeah, no, I think it's just, I think because Justice Muralidhar called me out a few times, like just for discussion. No, I think I'm just delighted to be here, right? It's my first engagement. So I just want to offer one kind of meta reflection based on some of the exchanges. See, I think one observation I've noticed is that people who are more kind of in the rights-based community tend to be nervous about state capacity in the hands of a potentially malicious state, right? And so there is a very real tension between people who think like kind of seeing like a state, right? Like, you say you want the state to be weak because a stronger state can in fact be overbearing. But the flip side of that is we also have a bunch of expectations with regard to protections of individuals, which also require state capacity. So the paradox, and in a way it reminds me a bit of like the Acemoglu narrow corridor, right? You need capacity to protect rights, but then the capacity has to be simultaneously circumscribed with, so it's a very delicate dance, right? Because if the rights go ahead of the capacity to do it, then you kind of, you feel shortchanged. But if you build the capacity of the state before kind of also building the rights, then that can also be abused. Like the CCTV is a good example, right? So CCTV, if used well, can in fact prevent the harassment of innocence if it gives you the footage, right? But it's also true that it creates a Pandora's box without the data protection. So it's a very delicate balance that we will all have to work on, So that was just a broader reflection, and then we can, have many more discussions on economics.
Yeah, I'll pick up the last one first. See, the problem is we should first have a law. We can't say everybody in this room can go out and drive cars. As and when accidents happen, we'll start thinking of a licensing system. That is a disaster. So we never had a data protection law, but we first installed CCTVs everywhere. And it's not just the state. My neighbor has a CCTV. Outside on the road, there are CCTVs. And today we have a situation, Ms. Borankar is here, and she will say, देखो एक और state का bashing हो गया. The policemen find their CCTVs are not working. They rely on the private shopkeepers' CCTVs. What is wrong? The whole thing is you're gathering data on private people which you are storing. In fact, this is a serious problem. Private people are storing data about other private people with no control by the state. Absolutely no control. They're sharing it with other people. I think it's a serious problem that we have on our hands. And no, if you monopolize violence, which is state violence is a monopoly of violence, right? Every other violence is illegal. When state commits violence, it's legal, because there are laws that permit state to commit violence. The more power you have, the more accountable you have to be. This is a very simple equation. I need not remind Ms. Borankar of that. She knows it better than everybody else. She can point out to me official statistics on Punjab disappearances, on Jammu and Kashmir disappearances, on encounter killings in Andhra Pradesh, the undivided Andhra Pradesh. Are there official statistics on this? There are Assam. You can take many, many places. See, we don't have a culture of introspection. We just don't have a culture of introspection. You will have the Pope apologize, many years later to the Jews, right? You will have some Trudeau apologize to the Sikhs for what happened in that Swagata Maru. Is that Komagata Maru? But we have no culture of introspection. We don't admit. We are in denial. The Sikhs in Punjab who lost many young people in those years have no answers. There we have movements of mothers have disappeared, grandmothers have disappeared. Are we going to be in denial of all of that? So the greater the power you use as a state, the greater will be the accountability, and you have to be called out for that. If private people commit similar offenses, they have to be called out for that. Anyway, this was only a response. I'm putting out an appeal on a larger sense. We've demanded that states share data. We've been agitated that state is not readily sharing data. All that is fine. The RTI Act says, put out data on your own. See, one answer should be that if I myself volunteer to put out data, which the Orissa High Court did, it voluntarily put up data on why cases were getting delayed, how much does it cost the system to run the judiciary, all that is there. But then you must volunteer to put up data as an agency. But I would urge even private persons should put out data. If we need not privatize data. You've gathered data. I'm talking about Daksh, I'm talking about Vidhi, I'm talking about Project 39A. There's a raw data that you've collected. Form a data policy at your end, put out that data. You've done some research for your project using some part of the data. Some other researcher will use that same data for some other purpose. You have your data policy. You talk about redaction, you talk about privacy, you build those elements, but do share data. As much as we want state to share all its data, whatever data we've gathered, let us share it. And let us not privatize data saying, oh, this was for my project, I will not share it with you, that you're doing some other project. So this is my appeal to everyone. Let's make this a more open exercise. Yeah. When we want openness.
So I think last, if there are last two questions. Yes, Swagata, please.
I think there was one question on looking at education and SC/ST, OBC data. And I think it so much matters as to how that data is interpreted, because it can also lend into bias very easily. And we see that in terms of, when we look at children in conflict with the law, there's a lot of talk about hotspot mapping, where is crime very high among children in conflict with the law. What are you going to do with that information? So will it lend in further into that bias that this is the community from which crime is, very high? Or are you going to look at like low education as a point of intervention? What kind of community systems need to be there? So it matters a lot who's collecting that data and for what and how is it going to be used. And many a times that is not in our control. So as private organizations doing research, I think we have to think very carefully what data points we collect, because the use of it is not going to be in our control. We can present our interpretation, and that same interpretation can be flipped on its head and used to make something else altogether. I'll just clarify, ma'am, I knew that question is going to come up, E-codes and NCRB. So that the scraping was done based on the starting point of the year in which the case was registered. So we did not look at past cases. We looked at cases that were registered from 2016 and then mapped that to the NCRB data. So we are not looking at cases that are pending before 2016 into our data pool. With respect to bail, we are in fact actually looking at bail orders in Romeo Juliet, romantic / consensual, whatever we want to call them. And we're seeing the patterns that we can see is age difference is sometimes a consideration. Intention to marry or marriage is sometimes a consideration. The fact that there's no previous record, the girls 161, 164 statements, these are considerations. And then, of course, I also want to point out that there are other harm reduction measures that states have adopted, like Tamil Nadu. The judiciary has endorsed the use of Section 41A CRPC, to avoid hasty arrest. So I also want to talk about data integration here, because there's a lot of talk on, under trials. We also have to share our data to see how many of these under trials are in POCSO cases, in cases of this type. And what kinds of measures can we take to at least, slim our prisons down in cases like this. So that's another conversation, yeah.
Thank you. The last response, okay. I think that's a very good and healthy session that we are ending. Before we break, I want to give a trailer of the next one post-lunch, where we'll have Project 39A talking about forensics, and then Christoph from Zurich Development Data Lab, followed by two very interesting speakers, the second of which is Mr. Mahesh Vyas from Center for Monitoring of Indian Economy. So let's break for lunch. There's all diets and all foods available, not just of one kind. Thank you.